Please be seated. May I now request the Judge of the Supreme Court of India, Honorable Mr. Justice D.Y. Chandrachud, to please make the introductory remarks.
The Honorable President of India, Shri Ramnath Kovind, Honorable Chief Justice of India, Shri Justice Sharad Arvind Bobde, Honorable Chief Justice of the High Court of Australia, Justice Susan Keifel, companion judges, and distinguished guests. The presence of the President of India in our midst today is of special significance. Before assuming the highest constitutional office, the President was a senior member of the Indian Supreme Court Bar until the call of duty to the nation carved out a course for the future. The role of a judge requires legal and constitutional statesmanship. The President's vast experience in matters both of the law and the state imparts to his presence a unique significance for us. The valedictory event of what has been an enriching conference on the judiciary and the changing world will, I hope, be a symbol of new beginnings. Above all, this conference has provided a platform for a dialogue among judges drawn from over 20 international jurisdictions. In many jurisdictions worldwide, judges holding appellate and constitutional office are drawn from the bar or upon a career progression as judges. Lawyering gives to the individual a steady stream of new information on which new thoughts and ideas can evolve. Crowded courthouse corridors are a vibrant space for dialogue and social contact. In contrast, judges live a staid, and some would say even an isolated life. The lively bustle of court corridors is replaced almost overnight by the calm and quiet of judicial chambers. Hence, experiences such as those gained from this conference rekindle the joy of being surrounded by new ideas and open the windows of our chambers and of our minds to jurisdictions across the world. Listening to and interacting with colleagues from across the world, what stands out is not our differences, but the common challenges that we face. Underlying the entrustment to judges by our Constitution of the function to decide cases is the belief that in the work of judges, the law is molded as an instrument of protecting constitutional values and ensuring justice to those in our communities who need it the most. Challenges posed by technology, climate change, and terrorism transcend individual jurisdictions. The insights gained from 2 days spent in the company of our distinguished colleagues from abroad indicate that justice knows no borders. Collegiality is the core of judging. All of us have gathered here as members of a global judiciary with a willingness to learn, to listen, to persuade, and be persuaded by each other's perceptions of law and life. This exchange of ideas and strategies is essential in assisting judges at crucial junctures in their decision-making. Perhaps the only thing greater than the power of new ideas has been the creation of new friendships and, in some cases, the rediscovery of old ones. The basis of these friendships traverses beyond our similar roles, our ties to a common judicial culture, and even the strong partnerships between our governments. These friendships are founded on the values and beliefs that have united judges through the ages, a commitment to render impartial justice and uphold the ideals of a representative democracy governed by the rule of law. Exciting developments have reshaped the universe of judging in recent times. The Supreme Court of the United Kingdom held that the constitutional functions of Parliament, including its supervision of government, could not be suspended without reasonable justification. The Constitutional Court of Malawi set aside a presidential election for being plagued with irregularities in order to preserve the integrity and legitimacy of the citizens' vote. The Constitutional Court of South Africa championed the rights of children and declared the common law defense of moderate and reasonable chastisement constitutionally invalid. The Constitutional Court of Colombia struck down taxes on sanitary hygiene products and ordered the city of Bogota to create a public policy on menstrual hygiene for women living on their streets. The High Court of Zimbabwe championed the cause of transgender persons under the protective umbrella of the rule of law by ordering the payment of compensation to a transgender person brutalized in police custody. The High Court of Kenya halted the implementation of the country's national biometric identification system pending the implementation of a robust data protection legislation. The Supreme Court of Jamaica accorded primacy to privacy and choice and struck down its national identification and registration systems. The Supreme Court of Bangladesh ushered in gender equality by altering marital registration forms. The Cour de Cassation of France gave impetus to a dignified life by upholding the withdrawal of life support to a quadriplegic person. At home, the Indian Supreme Court ruled that even the office of its Chief Justice is subject to a citizen's right to information. The doors of justice were thrown open not just for those seeking justice, but also to those seeking to scrutinize the court. This cross-fertilization of ideas is evident in the judgments of courts across the world, relying upon the affirmation of LGBTQ rights by the Indian Supreme Court. We, in turn, are enriched by the precedent from across the world. We learn from the wisdom of the others and grow together. In the judge's craft, comparative law turns from an abstraction to a reality. The initiative of the Chief Justice of India in convening this conference in a short span of a few months of his assuming office is indeed praiseworthy. The unspoken value of events such as this conference is to transform these historic judgments and many more like them from dead letters in journal articles to lived experiences with the very people who made them. In Kathleen Clubb versus Edwards, the Australian High Court upheld laws protecting the safety, dignity, and privacy of patients accessing vital abortion services. The judgment made for a fascinating read today, but I am privileged to share the dais with Chief Justice Susan Kiefel, who is a living embodiment of the quest for gender equality as the first woman Chief Justice of the High Court of Australia. Informational exchanges that we have had over 2 days allow for the planting of new ideas in faraway places, nurtured by warm human friendships, to ultimately blossom in the form of the next landmark judgment. To those who say you cannot teach an old hand that judges are sometimes known to have new ideas, I say that we are young in our minds and perhaps in our hearts as well. One of India's foremost lawyers and jurists, Fali Nariman, has said, "Howsoever old you may be, or howsoever old you get, may you always have the vigor and the enthusiasm of youth to appreciate the enormity and magnificence of the law and the will to unravel the mysteries and the mistakes of the law." It has given me immense pleasure in meeting and interacting with each one of you. I am confident that in the years to come, this will be an annual conference, a confluence which will mark a commitment to sharing experiences, exchanging ideas, and evolving together in the common pursuit of justice. Thank you.
Thank you, sir. May I now invite the Chief Justice of the High Court of Australia, Honourable Miss Justice Susan Kiefel, AC, to share her thoughts on the International Conference.
Your Excellency, President Kovind, the Honourable Chief Justice Bodhi, distinguished colleagues from near and far, ladies and gentlemen, it has been a privilege to be in Delhi for this important conference. It has been a short but a valuable time, made possible by the initiative of the Chief Justice and the extraordinary work of the organising committee in bringing us together to learn from each other. Chief Justice, I believe I speak for all the delegates when I thank you for the most generous hospitality that we have received. We are especially grateful for the cultural insights through dance and music which you have added to our program. The hospitality of the Supreme Court has made this a thoroughly enjoyable as well as a rewarding educational experience. The theme for the conference has been the judiciary and the changing world. That theme has been broad enough to capture systemic and transnational issues, whilst also drawing us into reflections upon the day-to-day work of deciding the cases that come before our courts. We have heard thoughtful and thought-provoking presentations on the role of the judiciary in maintaining and working for gender justice, in protecting the privacy of citizens, in harmonising environmental protection and sustainable development. We have discussed comparative perspectives on the role of the judiciary with respect to populism in its dual forms, as well as perennial questions in constitutional interpretation. Lord Reid gave us much to dwell on in his keynote address, which captured some essential aspects of the subjects which then lay before us. In these brief concluding remarks, I want to say something about the value of gathering to consider common legal questions, both questions that we encounter within the legal systems that we each call home, as well as transnational questions that concern us as inhabitants of a common home. In the task of judging, we are often caught up in the intricacies of our own legal traditions. Gatherings like this allow us to step back and see our own traditions in a broader perspective. Doing so reminds us of law's historical contingency, of its place in the broader fabric of national and international social order, and of its possibilities. To see our own legal traditions in comparative perspective is to see them afresh. That, I think, is one of the chief values of gathering to consider common legal questions. Let me briefly illustrate this point by placing the idea of constitutional principles in comparative perspective, considering how that idea appears in the constitutional law of India, the United Kingdom and Australia. My colleagues from other jurisdictions will forgive my focus on what are, for me, more ready and easy comparisons. January this year marked the 70th anniversary of the establishment of the Republic of India and the 70th anniversary of the Supreme Court of India. The Republican Constitution was born of the deliberations of the Constituent Assembly between 1946 and November 1949. According to one scholar, it is the world's longest codified constitution. Part 20 of the Constitution confers on the Parliament, in the exercise of its constituent power, a power to amend the Constitution. In interpreting the Constitution, the Supreme Court has identified a substantive limitation on the Parliament's power of amendment, the Parliament cannot alter the basic structure of the Constitution. The text of the Constitution does not expressly indicate what comprises the basic structure. The elements of the basic structure have been and continue to be worked out in judicial decisions. It has been said that they include the republican and democratic form of government, the secular nature of the Constitution, federalism, and the judicial review jurisdiction of the Supreme and High Courts. It is unsurprising that the elements of the basic structure have not been exhaustively identified. Constitutional principles are often, by their nature, open-textured. But what is clear is that the basic structure doctrine is a constitutional principle of the deepest kind, going to what one scholar described as the values and principles which must exist for constitutionalism itself to exist. And it is these values and principles of which the Indian judge has spoken about in these last 2 days, which serves to illuminate for the rest of us the role which your Constitution has given to your Supreme Court. Turning to the United Kingdom, the Supreme Court's decision in the prorogation case in September last year of Miller provided an occasion to consider the nature and effects of certain constitutional principles in that legal tradition. The Court noted that, I quote, "Although the United Kingdom does not have a single document entitled the Constitution, it nevertheless possesses a constitution established over the course of history by common law, statutes, convention, and practice. It includes numerous principles of law which are enforceable by the courts in the same way as other legal principles. In giving them effect, the courts have the responsibility of upholding the values and principles of the Constitution and making them effective. The legal principles of the Constitution are not confined to statutory rules, but include the constitutional principles of the common law." The Court went on to hold that the principles of parliamentary sovereignty and parliamentary accountability together operated to impose limits on the prerogative power of prorogation, limits which it is for the courts to adjudicate upon. Finally, let us turn to Australia. In 1901, the Commonwealth of Australia was established by a written constitution. Our constitution is a relatively short document, just 128 sections, with no list of fundamental rights, nor any reference to the office of the Prime Minister. It is, in many respects, a modest sort of constitution, as Justice Nettle of our court explained yesterday. In broad terms, one could say that it is more concerned with establishing procedures and structures of legality than with entrenching substantive rules of law. And indeed, that is how some of its framers conceived of it. But beneath its apparent modesty lie fundamental principles. Over the last 119 years, as the Australian legal system has matured, courts, and particularly the High Court, have identified, refined, and adjudicated upon the principles that underpin the Commonwealth Constitution, though those principles are, for the most part, not expressly articulated in it. There are several such principles. One Australian scholar identified 4 of them: representative government, federalism, the separation of powers, and responsible government under the Crown. These principles operate in different ways, are sometimes in tension with one another, and have different legal consequences, but they are all grounded in the text and the structure of the Constitution, interpreted in light of the common law as inherited from England and developed in Australia. The task of identifying, refining and adjudicating upon constitutional principles is one that engages many judges around the world. In one sense, it is a parochial task, dependent on the histories and legal systems in which we find ourselves. But what I hope this very brief survey illustrates is that it is also a task in which judges can learn from the approaches taken in other parts of the world, gaining a fresh understanding of our own constitutional arrangements, and by seeing them and the many issues to which they give rise in comparative perspective. That kind of vision, I trust, will stand us in good stead as we seek to engage with the legal challenges of a changing world. Thank you.
Thank you, ma'am. May I now request the Chief Justice of India, Honourable Mr. Justice Sharad Bobde, to please address the august Assembly.
Good afternoon. The Honourable President of India, Shri Kovind, the Honourable Justice Susan Keisel, Chief Justice of Australia, my esteemed colleague Justice Chandrachud and Justice Sanjay Kaul, my distinguished colleagues in the audience, Honourable Chief Justice and judges from various countries, Chief Justice of High Court, the Chairman of the Bar Council, office bearers of the SCBA, SCORA, senior advocates, members of the bar, the directors of the academies, member secretaries of state legal authorities, vice chancellors, members of the press, ladies and gentlemen. This conference is the result of many travels to South America, Africa, Europe, which gave me the pleasure of interacting with great minds from these jurisdictions. These interactions with sister and brother judges across the world instilled in me the firm belief that the value of learning from the experience of judges from other jurisdictions and sharing my own. I learned the truth of the words behind the words of James Russell Lowell: as one lamp lights another, nor grows less, so nobleness enkindleth nobleness. The last 2 days have been the culmination of that vision and belief. I thank the President of India the Government of India and all our distinguished guests who have made this vision a reality. The common thread that binds judges across the world is a commitment to dispensation of justice. This commitment underlies the creation of a transnational judicial network which thrives on the constant exchange of ideas and dialogue on common challenges that require our immediate attention. First and foremost, increasing diversity in the judiciary, as well as the role of the judiciary in ensuring a gender-just world. The judiciary, everywhere, is the guardian of constitutional values and serves to counterbalance populist forces in a commitment to the rule of law. Inherent in this role are active measures to bring women within the judicial fold. We have learned from the illuminating session on the judiciary and gender justice that incremental measures are only the first step towards championing the cause of gender equality. As judges, in the discharge of our duties, we are exposed to arguments, strategies, and solutions from various jurisdictions. The delivery of justice has not been untouched by the forces of globalization. Not long ago, legal education in a foreign jurisdiction was a rare oddity. Today, the vast majority of lawyers and judges are educated in more than one country. The globalization of the bar has been accompanied by globalization of the bench. Yesterday, I recounted some judgments of the earliest judgments of the Supreme Court, which took into account judgments of various jurisdictions in the world. Increasingly, confronted with transnational challenges, judges regularly reach beyond their borders to inspect the jurisdiction of other countries to discern valuable principles. Recently, judgments of and opinions of the Indian Supreme Court were cited by over 4 jurisdictions across the world. Our own judgments look to the wisdom of our international colleagues. Yet, a judge never loses sight of the need to tailor judicial decisions to the social realities of their own country. The Indian judiciary may not be in the present form, has an ancient origin. It is uniquely situated, connected by the yarn of history to the grand old traditions of the common law, yet also charting its own course in the face of a geographically, linguistically, and culturally diverse realities. India serves as a beacon of hope to independent and developing countries. The Indian Supreme Court is responsible for upholding the rights of over 1.3 billion people. We have approximately 17,500 courts in a country where over 22 languages and several thousand dialects are spoken. The Supreme Court has mandated the translation of its judgment into 9 languages. And I must again acknowledge here on this stage that the inspiration is the Honorable President of India. A commitment to access to justice furthers the commitment that constitutions are not meant only to check people in power, but also empower those who have been deprived of it. The provision of judgments in vernacular languages makes accessible to people from diverse linguistic backgrounds. As we look to the future, a significant consideration in the delivery of justice is the protection and preservation of the environment. In one of the cases before us, we have held that the present generation has no right to impede the safety and well-being of the next generation or the generations to come thereafter. This auditorium in which we are all seated forms part of a newly built energy-efficient additional court complex of the Supreme Court. This sustainable architectural marvel is an embodiment of the commitment of the Indian judiciary in making infrastructure in India sustainable. The complex has energy efficient LED lighting, and the solar grid is capable of managing 40% of the peak consumption. Environmental issues cannot be hindered by national and international borders. Water and wind flow seamlessly across the earth and even under it. The growth of vegetation affects the animals and man affects both. Perhaps there is the greatest need for a single system of laws globally on this issue. It is said that human beings are seeds as well as parasites to the earth. We take much more than we give back to the earth. As Richard Rogers said, the only way forward to improve the quality of environment is to get everybody involved. In India, we are using technology in innovative ways to facilitate and assist the delivery of justice. Indian courts are located across the length and breadth of our vast country. As a part of the e-courts project in India, we have ensured that no matter where a judicial officer is located, from the remote mountain tops of the Himalayas to the sandy beaches of Kerala, they are electronically connected to the National Judicial Data Grid. We have harnessed the rise of smartphone technology and telecommunications connectivity to streamline the delivery of justice, delivery of service and summons, empowering our bailiffs to reach litigants accurately and efficiently across the country. And you will realize what a dire need there is of this, because in many high courts, about 19 to 20% of the pendency is from negotiable instrument cases. And every second case is held up because summons have not been served. As we head into the future, we are exploring the use of artificial intelligence to automate simple tasks associated with the administration of justice. With a reading speed of 1 million characters per second, the volume of any data for any purpose, whether research or analysis, becomes easy to deal with. But it must be treated as a tool, and its introduction into the judicial system must be done with hesitation and caution, lest it grows in directions which affect human discretion. But probably it never will affect human discretion, and the human mind is bound to retain its supremacy. A small question and answer allays apprehensions. Would any of us have travelled to this auditorium to hear a computer speak? The conference has also presented us with an opportunity to discuss the myriad ways in which a foundational document can be interpreted. Drawing on the maturing traditions of comparative constitutional analysis has afforded us an opportunity to learn from the unique historical experiences of each other. The last occasion being 10 minutes ago, Justice Susan Caiffel's speech. Finally, across the world, significant strides are being made in the employment of technology in the dispensation of justice. As I stand here today, I am conscious that there is much work to be done both in India and across the world. There are two facets of globalization that have posed the greatest challenges to the judiciaries across the world, are the rise of global supply chains and the proliferation of information technology. Technology has placed the world in the palms of our hands, making it possible to communicate with great ease across the world. But the widespread use of technology has also brought with it concerns over mass data collection and an individual's right to privacy. Beginning in the 16th century, the goddess Justitia, or as we are more commonly know her today, Lady Justice, has been depicted blindfold. The blindfold personifies the principle of impartiality and that justice is blind to power, wealth, or status of the parties before her. While impartiality remains at the heart of a judge's duty, judges are called on to look beyond the parties and into the future, to anticipate future developments in the world and ensure the courts of today are ready for the world of tomorrow. The last 2 days represent the first step taken in India towards crystallizing a broader international dialogue amongst members of the judiciary from various countries. As they say, one cannot travel very far unless one begins very near. I hope that in the future, not only will this conference become a regular feature of the judicial calendar across the world, but a shining symbol of a global network of guardians against injustice. Thank you. Jai Hind.
Thank you, sir. May I now request our chief guest, the Honourable President of India, Mr. Ramnath Kovind, to please give the valedictory address.
Chief Justice of India, Mr. Justice Sarath Bobde, Chief Justice of Australia, Madam Justice Susan Kiefel, heads of the highest courts in their countries, namely Mr. Justice Saeed Yusuf Halem of Afghanistan, Mr. Justice Syed Mahmood Hossain of Bangladesh, Dr. Justice Emmanuel Uzra Sebuza from East African Court of Justice, Mr. Justice Brian Sykes of Jamaica, Mr. Justice Ahmed Mutsim Adnan of Maldives, Mr. Justice Jayanta Jayasuriya of Sri Lanka, Mr. Justice Robert John Reed of the United Kingdom, Mr. Justice Luke Malava of Zimbabwe, Dr. Justice Dalveer Bhandari of the International Court of Justice, distinguished judges and heads of delegation from France, Ghana, Indonesia, Kenya, Malaysia, Morocco, Myanmar, Nepal, Nigeria, Peru, Russia, Spain, Sudan, and Thailand. Distinguished judges of Supreme Court of India, Dr. Justice D.Y. Chandrachud and Mr. Justice Sanjay Kaul, judges, jurists, and members of bar from India and abroad, and distinguished participants, ladies and gentlemen. It is indeed a pleasure to address the valedictory session of the International Judicial Conference organized by the Supreme Court of India. In popular perception, all is well that ends well. But this conference began on a strong note. While inaugurating the conference, Prime Minister Narendra Modi, I am told, highlighted the supremacy of law and lauded the role of judiciary in maintaining a delicate balance between developmental needs and the environment, as also in resolving complex issues through verdicts acceptable to all. I am also happy to note that the ethical and duty-oriented vision and expectations of Mahatma Gandhi were shared with the participants to enrich international jurisprudence. It has been highlighted that developments related to demographics and technology and awareness about rights are causing changes having wide ramifications. I am happy to note that the role of judiciary in harmonizing environmental protection and sustainable development is being given sharp focus in various countries. Similarly, the universally accepted norm of gender justice was also discussed with an approach to finding ways forward in the light of practical experiences in different justice systems represented in this conference. Here we have a galaxy of judges and jurists representing different parts of the world. Thanks to your participation in various sessions, I have no doubt about the high standards of deliberations in this conference and its impact on resolving contemporary problems in a changing world through legal interventions. The deliberations in the past 2 days, I am sure, will go a long way in enriching jurisprudence at the international level. Ladies and gentlemen, the theme chosen for the conference is timely and apt, that is, judiciary and the changing world. In a way, change is the only constant, and the world has always been changing. In recent years, however, the world has been changing very fast and in unforeseeable ways. The role of the judiciary is bound to be pivotal amid these dramatic transformations. The selection of the topics for the working sessions of the conference could not have been more meaningful. Gender justice, contemporary perspectives on protection of constitutional values, dynamic interpretations of the Constitution in a changing world, harmonization of environment protection vis-à-vis sustainable development, and protection of rights to privacy in the Internet age are issues that influence every member of the global community. These 5 distinctly defined topics cover the matrix of challenges faced by the judiciary across the world. Gender justice must remain high on the global agenda. The past decade has witnessed a debate on rising populism in the context of constitutional values. This has, in turn, led many to take a fresh look at their founding documents, the constitutions, again. With the evolution of information technology, there have emerged new questions, for example, of data and privacy. Finally, the all-important concern of sustainable development should command far more attention than it does today. You have held wide-ranging deliberations on these issues and suggested measures to overcome the challenges. Ladies and gentlemen, I am glad to note that the judiciary in India has been alive to these themes and has approached them in the light of the vision behind the Indian Constitution. In pursuing the cherished goal of gender justice, to mention one example, the Supreme Court of India has always been proactive and progressive. From issuing guidelines on preventing sexual harassment in the workplace 2 decades ago, to providing directives for granting equal status to women in the army this month, the Supreme Court of India has led progressive social transformation. With the same sensitivity, it has approached the emerging questions of biodiversity and sustainable development, keeping in mind our age-old ethos too. In the process, the Supreme Court has learned from the best practices of the apex courts abroad, just as the judicial systems elsewhere have emulated it in many instances too. Such exchanges should be wholeheartedly welcomed in the spirit of Vasudhaiva Kutumbakam. That is our ancient Sanskrit adage, which means the whole world is but one family. It thus calls for a holistic approach to the entire humanity. Ladies and gentlemen, the Supreme Court of India also deserves admiration for carrying out many radical reforms that made justice more accessible to common people. Landmark judgments passed by this court have strengthened the legal and constitutional framework of our country. Its bench and bar are known for their legal scholarship and intellectual wisdom. What it has achieved is nothing less than a silent revolution in diagnosing and correcting the afflictions that adversely affected the justice delivery system. For example, the recent move towards introducing an alternative dispute resolution mechanism is expected to reduce the burden on the court to a considerable extent. Dispute resolution through mediation and conciliation would help resolve the problem amicably in an effective manner instead of resorting to a lengthy litigation process. To speed up the justice delivery, of late, the Indian courts have been adapting to new technologies and also considering the potential of artificial intelligence. We have been using information technology to ensure hassle-free proceedings in the court in high-profile cases. Evidence is often recorded through video conferencing. Technologies are being used to facilitate trial without hindrance. I note that the Supreme Court of India is also actively considering the ways to make courts paperless. This will obviously pave the way for speedy trial and delivery of quick justice. Such innovations, I am confident, will also trigger similar changes in lower courts in due course of time, benefiting more and more people. Ladies and gentlemen, I will also refer to the yeoman service rendered by the Supreme Court in making the higher courts judgments available in regional languages. This is indeed an extraordinary achievement given the linguistic diversity of India. As of now, the judgments of the Supreme Court get translated in up to 9 Indian languages to make them accessible to common people. I am sure that its scope would further widen with the passage of time. Ladies and gentlemen, I hope you all will return to your respective seats of justice and jurisprudence with a host of ideas and with the determination to implement those which have transformative impact. I am sure that the deliberations of the conference will help strengthen the judicial system not only in India but also in other countries. I am glad that the Chief Justice of India gave me this opportunity to share my thoughts with such a learned audience. I also congratulate him and his colleagues for organizing this International Judicial Conference. Building on its success, I am sure the conference will become an annual event organized in different parts of the world for consolidation of best legal practices and ideas towards helping shape a better world. I wish you all the best in your endeavors. Thank you. Jai Hind.
Thank you, Mr. President, sir, for your inspiring words. May I now call upon the Judge of the Supreme Court, Honorable Mr. Justice Sanjay Kishan Kaul, to please give the vote of thanks.
Kano Bhadra Kratto Yantu Vishwata. It is 5,000 years ago in Rig Veda, where it was said